Hello, and welcome back to Inside the Contract. We are still on season 2. This is episode number 9. Today, we dive into one of the most high-risk areas of contract administration, which is the termination. Termination, as I view it, is a nuclear option. Used correctly, it protects a party from ongoing breach, financial damage, or prolonged non-performance. Used incorrectly, it becomes a devastating mistake, leading to counterclaims, reputational damage, and significant exposure in dispute resolution. In this episode, we break down how FIDIC treats termination, how to avoid wrongful termination, and how to use these clauses with precision and caution. Okay? Let's get to it. What are the types of termination in FIDIC? FIDIC 2017 provides 4 main pathways to termination, each with its own tests, procedures, and consequences. First, employer's termination for contractor default, Clause 15. Common grounds include failure to proceed with due diligence, failure to provide performance security, abandonment of the site, serious or repeated breach of the contract, bankruptcy or insolvency. Okay. Second, contractor's right to suspend or terminate, Clause 16. Grounds typically involve non-payment for more than a certain number of days, depending on how the contract is drafted, prolonged suspension ordered by the engineer or the employer, failure of the employer to give necessary instructions, breach of employer obligations affecting execution. Third, termination for convenience, which is a clause 15.5. The employer may terminate without cause, but must compensate the contractor fully. Okay? 4 is termination due to exceptional events, clauses 18.5, and this one was the clause 19.6 in the 1999 FIDIC. FIDIC allows termination following prolonged prevention due to exceptional events, typically framed, around a continuous 84 days or multiple periods total in 140 days, depending on the applicable book or edition and the particular condition. Why structure matters? Each termination category comes with mandatory notices, cure periods, engineer involvement, payment consequences, variations, and entitlement. Missing any step can convert a lawful termination into a wrongful one, even if the underlying breach was genuine. Okay, so structure and discipline following the procedure to the teeth is very essential in this case. So let's look at the termination for default. Employer termination for default, Clause 15, is the most complex and most litigated version of termination. Typical triggers include abandonment of the works by the contractor, failure to comply with engineer's instructions, non-maintenance of performance security, insolvency or bankruptcy, consistent failure to meet contractual obligations. However, the key risk is procedure. Even if the contractor truly breached the contract, termination is only lawful if the contractual notice sequence is followed, often employer notice to correct, cure period, and then termination if not remedied. Second, the engineer's role, if any, is handled exactly as the contract requires, assessment, certifications, and determinations. Okay. Termination by the contractor. Contractor termination, Clause 16, is rare, but extremely powerful when used properly. Grounds include non-payment for a specified number of days or more than that, FIDIC typically ties contractor termination for non-payment to expiry of the payment period plus additional waiting time and notice requirement under Clause 16. The exact durations, again, vary by book and edition and the particular conditions. Second, prolonged suspension ordered by employer or engineer. Prolonged suspension ordered by the employer and the engineer. If a suspension under subclause 8.9, suspension of the work, continues for more than 84 days, subclause 8.12, which is prolonged suspension, allows the contractor, in certain circumstances, to terminate under subclause 16.2. Okay? Third, failure of employer to provide necessary approvals, access, or instructions. If the employer obstructs progress materially, in practice where contractors have succeeded, the pattern is consistent. Strict notices, contemporaneous evidence, and step-by-step compliance with Clause 16. Okay? But why contractors rarely use Clause 16? Several factors. First, fear of retaliation, fear, future tender implications, pressure to keep going, lack of understanding of the clause's strength. So nevertheless, Clause 16 is a legitimate and enforceable off-ramp when the employer materially breaches payment conditions. Just to note here, what I have seen in most of the projects I have, been familiar with, these clauses, termination by the contractor, are heavily modified. The employers mostly use the FIDIC books, but they modify them. And most of the modifications, I've seen involve, contractor's risk. One of the things I noticed, because there was a case and I was involved in, the contractor's termination by the contractor was limited to the payment, and it was really complex and long durations. So this is something I like to mention to everybody involved in drafting contract. Again, to be very aware of situations like this, termination rights by contractor. It's very important. Okay. Clause 15.5 allows the employer to terminate without cause, a powerful tool that must be handled responsibly. Compensation in this case must include work properly executed and certified or valued, proven costs and commitments reasonably incurred, including demobilization, reasonable profit where the contract provides for it, and valued work and or termination costs. Usually it avoids profit, on unexecuted work. I avoid this as a blanket rule, okay? Of course, there is the talk about misuse and abuse. If the employer uses Clause 15.5 as a disguised attempt to escape responsibility, re-award the job to a cheaper bidder, avoid paying legitimate claims, this may be viewed as bad faith or disguised default termination. Okay? The risk exists. What really worse than this, termination for convenience is one thing. It might actually compensate the contractor to a certain extent. What I have seen, unfortunately, termination for convenience being disguised under termination for default so that the employer escapes responsibility. Okay, I've seen this, and unfortunately, some contractors suffer greatly in such situation. Okay, so what are the wrongful termination risks? Wrongful termination is one of the most expensive mistakes a party can make. Okay, typical causes of wrong termination include misinterpreting breaches, acting prematurely without proper notice, failure to follow cure procedures, no engineer involvement were required, overreacting to minor breaches, or termination driven by emotion rather than evidence. And I will add to that also the disguised termination to escape responsibility. Okay? So the consequences: exposure to counterclaims and damages, and potential loss of terminating party's position. Okay? Contractor claims for damages, lost profit, and prolongation costs. Arbitration costs, severe reputation harm, delays to project delivery. Tribunals focus heavily on two things: materiality of the breach, procedural compliance. A defensible termination means both material grounds and flawless procedures. Okay? So let's look at some really illustrative case scenarios here for some projects in the region. These are illustrations. Case 1. The employer terminated without obtaining a proper engineer certification. The tribunal ruled the termination wrongful because contract procedures were ignored, no valid basis was documented, the contractor was not given proper cure opportunity. Result: employer paid demobilization plus loss of profit on unperformed works. Okay? Termination for default is not just about being right, it's about following the contract to the letter. Another case: employer terminated for delayed mobilization, but evidence showed delays were minimal. Tribunal ruled the breach not material, termination wrongful. A case in South Asia: contractor terminated after 100 days of non-payment. Employer claimed financial restructuring. Tribunal upheld contractor's termination, citing strict Clause 16 payment protections. Another case: employer termination upheld due to repeated contractor defects and multiple failures to cure. This ruling demonstrates that termination can be lawful when heavily documented and procedurally sound. Each case of these reinforces the same lesson: termination decision live or die by documentation and process. Okay? So let's look at some practical tips to manage termination risk effectively. First, treat termination as the last resort, only after exhausting all contractual remedies. Second, issue clear warnings. Your notices must be documented, dated, and explicit. Third, keep complete records, minutes, correspondence, engineer instructions, and site diaries. 4, engage the engineer early. Their assessment is often a procedural requirement. 5, seek legal contract advisory support. Because termination is always high stakes and often irreversible, termination is as much as legal process as it is a contractual one. And if I have not mentioned this earlier, I'm going to mention it here. Termination process must be handled by extremely experienced contract professional with strong legal background. This is not something that can be taken lightly. Okay, it's a very high stake subject and shall be handled very carefully. So what is the key takeaway here? Termination is both a weapon and a shield. Used correctly, protects your rights, limits losses. Used recklessly, triggers claims, damages credibility, and leads to costly consequences. Understand the contract, follow the steps exactly, document everything, and only pull the trigger when there is no other option. I hope the message is clear. By this, we come to the conclusion of episode number 9. Again, and as usual, I thank you for watching. In the next episode, episode number 10, which is season 2 finale, we will explore how to craft resilient contracts that withstand disruption, claims, and disputes. Again, thank you. See you next time.